Good afternoon, ladies and gentlemen. Welcome to the webinar, Don't Sign That Contract Yet. 5 signs that you're about to sign an unfair construction contract. This is a webinar brought to you by AIA Contract Documents. We thank you for joining us today. A few administrative items before we get started. This presentation is protected by U.S. and international copyright laws. Reproduction, distribution, display, and use without written permission of the speakers are prohibited. This program is also registered with the American Institute of Architects for 1 learning unit. A disclaimer here, this and all programs brought to you by AIA Contract Documents are not provided as legal advice. These are for informational purposes only. We always suggest that you meet with your counsel. And with that, I'm going to turn it over to our presenters to present themselves. Let me turn it over to Colleen Telling. Colleen?
Thank you, Hosti. Good afternoon. My name is Colleen Telling, and I am an attorney with the AIA Contract Documents program, where I have worked for the last 4 years. Prior to this role, I practiced municipal, contract, and real estate law at a private law firm in Cleveland, Ohio. I also worked for 5 years in construction management and contract administration for a national construction firm that was engaged in heavy civil and infrastructure projects in Virginia.
My name is Jimmy Germano. I work with Colleen and with Mike with AIA Contract Documents. I'm also an attorney working with the AIA Contract Documents Committee. Before joining up with the AIA Contract Documents program, I was an attorney in private practice focusing on construction, litigation, and contract issues in the DC area. And I will hand it over to Mike. Mike?
Excellent. Thanks, Jimmy. My name is Mike Koger. I am also an attorney with the American Institute of Architects Contract Documents program. I've been working with AIA for about 7.5 years, going on 8 right now. I started my career as an architect, went to Ball State University, studied architecture, and actually worked in the field as an architect for about 5 years. I practiced in private practice for about 4 or 5 years, representing owners, contractors, design professionals, and a little bit of everyone in the construction realm. I have to I'd say, Jimmy, I'm pretty excited about this program because, you know, most of the time we do webinars, we actually focus, of course, on AIA contracts. And AIA contracts, for as much as I love them, they are not very controversial. And that is, of course, on purpose. I mean, we try to draft things that are about as uncontroversial as they can be. When you read an AIA contract, I mean, most of the time you're going to say to yourself, yep, that makes sense. That's about right. And today, though, we get to talk about some very controversial things, some provisions that when you read them, they might make you a little bit angry. They might make you, yell at your pets as to why is this provision in my contract? I know, this is a relatively informal webinar. A lot of the times we rehearse our remarks, to death sometimes. But today we're going to, I know, for example, that Jimmy's going to be talking about indemnity provisions. I know Colleen's going to be bringing up liquidated damages. So that's kind of a preview of some of the things we're going to be talking about. But I'm really curious to see if what they have to say about those topics comports with what I think is somewhat unfair. I'm also going to be, during this program, outing myself a little bit. I know in private practice, I've done a lot of the tactics and I've inserted a lot of the language that we are going to be labeling as, somewhat unfair throughout this program. So, and I know I've seen in private practice quite a few of these things come across my desk, and so we'll give you some tips as to how to deal with them. Short of, of course, sending them to your attorney for review, which is obviously something you should be doing. A couple of more disclaimers before I get into the very first topic. One, there are really no universal rules for fairness. So we're going to be liberally using the word unfair, or whatever during this program. There are exceptions to every rule. So pretty much everything that we say in here, you can think of an exception where, well, that's okay in this instance. But at least in our experience, the things that we're going to be talking about here are things that heavily shift the risk profile from one party to the other, and particularly putting risk onto a party that might not have the ability to control it. So those are the kinds of things that we're going to be calling out as, things that you should think twice about before signing your contract. A couple more things. You know the laws of your state better than we do. We're going to be talking about things like liens, indemnity, and so on. These are all things that are heavily regulated in some instances by state law. We're going to be talking more generally about these topics, but if you have a question about, liens in Utah or something, then definitely you'd want to talk to an attorney in Utah who knows their laws. And one other thing, we're doing like a top 5 here, but in reality, we're doing 6 topics. And at the end of this program, we're going to have a lot of honorable mentions. So stick around for the last 10 or 15 minutes because we're going to kind of rapid fire go through some things that didn't quite make our top 5 or 6 list. Jimmy, you want to advance the slide and we'll talk about the first topic?
Sure thing. Thanks, Mike. And I think the first topic is all yours.
Excellent. By the way, Colleen, are you back on the call?
I am back on the call. I don't have an internet connection, but I'm here via phone.
Excellent.
Welcome back.
Welcome back, Colleen. We'll catch up with you here in a minute. I'm about ready to jump into our first topic. And it's, I'm labeling it, what's the rush, right? And this is really a tactic more than contract language. It's something if you've been dealing with contracts for a long time, or any time at all, you've been in this, situation where you've got one party trying to apply pressure on the negotiating process by setting a really quick deadline. I need it by the end of the day tomorrow. I need it in 24 hours, or this deal is gone. And then also kind of part and parcel with that is the idea of not negotiating. The other party will not negotiate reasonable concerns. If you're looking at a contract that somebody else has prepared and you've raised what you think to be an objectively reasonable concern, and the other party says, hey, take it or leave it. Those are 2 major red flags. And now you can imagine scenarios, government contracting or something where you literally, the other party just is not able to negotiate a term. And you can also imagine a lot of different instances where, time might truly be of the essence. But oftentimes these are used as tactics to kind of rush a decision and to really, get one party just to imbalance the power of the negotiating process and to hurry the other person into signing something that's against their interests. So those are just things that I know in contracting. When I get those things applied to me as counsel on the other side of receiving a contract, I always flag those as, all right, I need to really pay attention here because if they're looking for me to sign a contract really quickly, I know I need to scour it to make sure it doesn't have anything ugly in there that's going to really hurt me. So typically speaking, my response is to we have to have a contract signed really quickly is, well, why? Is there a tangible reason why you need me to sign this thing by the end of tomorrow that makes sense? And there's always going to be some tacit reason, but there needs to be a real reason why. And also to, push back on that and say, hey, what about 48 hours? What about 72 hours? Because truly that would give you the time to review the contract, unless it's something extremely simple. My response to the no ability to negotiate reasonable concerns issue is, if it's a big enough issue and you won't let me kind of negotiate to something that's fair, it's not a bad idea to walk away from contracts like that, particularly if you're getting a sense that, the other party is just trying to get you to agree to something that would really shift the risk profile heavily against you. A lot of times when you see this tactic used against you or used on you, you're going to see 2 other provisions that often pop up in a contract. It's the provision that you see here as the second bullet point on this slide. It's the opportunity to consult with an attorney if you really got a quick deadline. I mean, typically you're not going to have time to consult with an attorney. Also, a provision that you'll see in a contract that says that the contract will not be construed against the drafter. Neither of those provisions in and of themselves, you'll find those provisions in a lot of contracts. There's really nothing wrong with them. But when you tie them together with the rush to get the contract signed for no good reason and not able to negotiate reasonable concerns, that is really more of just of trying to cut off potential challenges to the contract later on. If, for example, you say, hey, you try to make the argument to a judge or an arbitrator or someone that I didn't have a lot of time, I couldn't consult an attorney, so whenever you get this kind of dynamic going on a project, definitely pause and certainly do send it through to your attorney and get enough time to actually review the contract. Jimmy and Colleen, I know you've had this particular tactic used against you, and you've probably done it to other folks before. Any other thoughts on the rush to get the contract done?
Coger, I don't know what you're talking about. I've never tried doing that to anybody.
Yeah, right.
I will say that this issue can come up. You might be starting a contract negotiation knowing that you need to have wet ink on the contract like 60 days from now. So you know you have 2 months to negotiate and sign, but the what's the rush portion might come into play when you get through like later versions and later revisions. So maybe it took you 59 days to get to a point where like now you're going to talk about your, no damages for delay clause. Now you're going to talk about your indemnity provision. So you may have had all the time in the world, but then you get to a point where it's, well, we need this agreement signed within 24 hours of right now. So it's not always when it's first handed to you. This kind of what's the rush concern can creep up on you as negotiations go forward. So it's not a binary sort of, it either is or it isn't. It can kind of slowly develop over time where there becomes that time crunch toward the end. And I mean, that's kind of how every contract negotiation goes, but it's on that sliding scale for sure.
And I would add, Mike and Jimmy, just that in the real estate context, when it comes time to signing purchase agreements, 24 to 48 hours is not such an uncommon time frame for a seller to take to look over the contract and decide to move ahead with a potential buyer. That tends to be the same with new construction too. A potential home buyer is generally given 24 to 48 hours to say yes to the contract or make any negotiations and move forward at a definite pace.
Yeah, that's a good point. I mean, you've really got to use your judgment with this one, and that's why I wanted to put all of these factors together. It's not just one thing. It's not just the I need it tomorrow. It's also, and what I think is probably the biggest thing, I've buried the lead here, it's not able to negotiate reasonable concerns. And you can see that through all of the other topics that we're going to talk about. If you can't negotiate a reasonable concern, big red flag on that contract in general. Should we go on to the next one?
Sure. So number 2, second sign that you might be signing an unfair construction contract is that it might contain a broad form indemnity. And what do we mean by that? So generally, indemnity provisions require one party, known typically as the indemnitor, to cover the costs of another party, known as the indemnity, in the event of a loss or a dispute. These types of clauses can vary greatly in how much and what types of losses they require the indemnitor to pay. So an example of, and having said that, obviously not all indemnity provisions are unfair. You're going to find indemnity provisions, they're going to be typical in most construction contracts, but there's a couple nuances that might, in certain circumstances, might make them unfair in your particular project. So that's what you want to look out for. So an example of a potentially unfair indemnity provision is one that requires the indemnitor to pay for the entire loss regardless of who was at fault. And that's sort of the number one big red flag. Those types of indemnity provisions are sometimes referred to as broad form indemnity provisions. So the first bullet point that you see on your screen right now talks about indemnifying for the indemnity's sole negligence. I know it's a bit of a mouthful, but in these types of provisions, essentially what's happening is the indemnitor is paying for all of the damages, even though it was the indemnity who was solely at fault. I'm going to dive into this particular type of clause and some of like the public policy arguments for and against it in a few moments, but it's easy to see how that type of framework can be unfair. For example, if you're looking at a subcontract and it says the subcontractor is going to indemnify a contractor, even if it was the contractor who was solely negligent, well, a subcontractor might look at that and say, that's a little unfair because we didn't do anything wrong, but we're paying for all of the loss, for example. The second bullet point on your screen talks about uninsurable indemnity obligations. And this one is a little bit nuanced. So here's how it works. For this type of issue, it's important to remember that most general liability policies are going to cover losses that are caused by the insured's negligence. Obviously, you need to read your policy, and this might not apply always, but this is the concern to think of. If you have a CGL or professional liability policy where it covers your negligence, think losses that are caused by the negligence of the insured, that doesn't necessarily include your indemnity obligations, particularly when you have an indemnity clause that's broad form and you're indemnifying somebody for their negligence. So sort of by definition, your insurance is not going to come into play. So if the insured is responsible for indemnifying someone else for their negligence, that particular indemnity obligation might not be covered by certain types of insurance. So it's a little bit of a nuanced issue, but that's how your insurance obligations, your insurance policies, what your coverage is, how that's going to interplay, if that's a word, with your indemnity obligations under your construction contract. Lastly, you'll see a reference here to state anti-indemnity statutes. Some states, I think right now it's roughly about half, if memory serves, that have enacted things that are called anti-indemnity statutes. These statutes typically prohibit parties from entering into an indemnity agreement whereby the indemnitor agrees to indemnify the indemnity for their sole negligence, the indemnity's sole negligence. So an example of this type of statute is going to be the one that was enacted in Maryland. And I'll show that here on the screen. So this is the Maryland statute. It's Maryland Courts and Judicial Proceedings, Article 5-401. I'm not going to read the whole thing, but just so you get a flavor for how these types of statutes can be worded, reading just the underlined portions gives you a flavor for what they're talking about. So a covenant, promise, or agreement or understanding purporting to indemnify the promisee against liability caused by or resulting from the sole negligence, and that's the important part, of the promisee or indemnity is against public policy and is void and unenforceable. So basically, if you have an indemnity clause that says sole negligence or something like that, that clause is void. That's going to be against the public policy of the state. And usually, different states can treat it differently. The question then becomes, what happens if you do happen to have one of these in your contract and it's void? How does that work? Does the entire contract get thrown out? Is it just this clause that gets thrown out? Does the clause just get reworded? And that's something you'd have to go to an attorney in your jurisdiction and figure out, okay, well, you know, maybe I have one of these and maybe my state has an anti-indemnity statute. What's next? What happens next? So I previewed a little bit that we're going to talk a little bit more in depth about broad form indemnity, sole negligence, complete risk shifting. This is an excerpt from a leading construction law treatise about sole negligence indemnity provisions. So I'm not going to read the whole thing, but I will highlight a few sentences at the end which do a good job summarizing the argument against these types of provisions, the public policy argument. And you'll notice here that it refers to the provision as risk shifting. The argument against these types of provisions goes that if the indemnity knows going into a project that they are going to be indemnified for their own negligence, so basically they can be negligent and someone else is going to pay for it if something goes wrong, then they will act more risky, in a more risky manner than they otherwise would. That's sort of the argument. Now, personally, I think I've seen research that suggests that this argument doesn't really hold water in reality because, you know, a ton of decisions go into how people act on a construction project. And, you know, if you have a construction or, you know, project manager walking the site making decisions, they're not necessarily thinking, oh, well, we have, you know, a certain type of indemnity clause. I'm going to do X, Y, and Z as a result. That's not usually how people think. But the theory behind it and the public policy arguments behind why these provisions might be risky and might be unfair still remains. And with that, Mike and Colleen, I'll hand it over to Colleen to talk about another fun topic, unless you want to talk about indemnity for a minute.
Oh, I've got a follow up to that, and I think that indemnification provisions are notoriously confusing, right? I mean, as soon as you started saying indemnitor and indemnity, those two terms, I instantly was happy that you were taking this section of the program instead of me, because I even get confused on those, and I probably reviewed 1,000 indemnification provisions. So, when folks, what happens a lot of times when folks, contractors, owners, architects who've been around and they've read contracts before, it is really when they get to the indemnification provisions in a contract that they are like, oh my gosh, now I need to I got to go see an attorney because I can negotiate everything else. But the very precise nature of the wording in these kinds of provisions is so complicated, and the interpretations of them can be so nuanced and really do follow case law in a lot of instances, that's really what gets folks to have their contract reviewed by an attorney, which is not necessarily a bad thing at all. I would suggest to folks that, like, if you want an example of an indemnification provision, like between an owner and a contractor that is, has been vetted, it is written to comply with the laws of, I assume, every state, but I believe it is every state. Take a look at the A201 section 3.18. That is a indemnity clause that, is limited to the contractor's negligence. And that, at least in my mind, is where indemnity is most, acceptable, when you've got one party, a contractor who's out there doing work that could actually end up resulting in lawsuits to the owner. To me, that makes sense to have an indemnification, kind of language, as long as it's appropriately limited.
Sure. And I actually like to dovetail on the 3.18 clause in the 8201. There's 3 words in there that sort of make that clause or push it in the direction of being fair, and it's because it contains the words "to the extent," and that if you're reading the indemnity provision quickly, you might read that and maybe not know exactly what that means or what type of effect that might have on the indemnity obligations or the scope of the indemnity. But just throwing in a couple little words like that has a huge impact and tends to keep it fair for reasons that we can go into on another webinar.
Yep. No, I completely agree. I mean, I'll tell you, when I get an indemnity clause that I'm reviewing for a client, and I have to think back, many years when I was actually, not working for the AIA, but when I would get these kind of clauses, I would, it's one of those where, all right, I got to sit down, I got to drink a cup of coffee. Where are they trying to hurt me in this provision? So, and I actually got to read through it very carefully. And a lot of times I end up, either going to the AIA language that has already been vetted by, numerous experts and had folks, really pour over every potential ramification, or I just say, no, we have to cross this out. Or the other negotiating position is often, well, if you want me to offer you indemnification, then I want a reciprocal one that's worded exactly the same. That's usually a negotiating position you'll hear from folks. It doesn't always make sense like that, but you do get that quite often. Colleen, did you have anything on indemnity before we jump to the next one?
Yeah, I would agree with you both that indemnification is a bit of a tricky topic. If you are in the contractor's shoes, definitely read that provision closely. If something strikes you as you're providing indemnification to somebody who's not in privity of contract with you, so not in that direct contractual line, your subs under you, and indemnifying the owner and architect of your project, if it's outside that realm, that should raise your eyebrows and invite some negotiation with the other party.
Oh yeah, I mean, whenever I see like a broad form indemnity, my instant thought is, did you not think I was going to read this? Like, I'm just like, how now I have to look at this contract extremely closely. So.
All right, well, let's move on to number 3. Colleen, I think this is yours, talking about liquidated damages.
Right. Well, liquidated damages don't necessarily make a contract unfair. In fact, they've been around since the 15th century in England, and you have probably seen them in many contracts that you have signed. Liquidated damages are meant to be a reasonable estimate of damages in case a party breaches a contract. This is important because when a party contests paying liquidated damages, courts evaluate whether the amount is reasonable based on the amount of anticipated loss when the contract was executed. The important thing is that liquidated damages are not to be used as a penalty, and you'll often see a phrase to this effect following the stated amount of the LDs. Liquidated damages are considered a penalty and thus invalid when they are grossly excessive and disproportionate to the damages that might reasonably result from a breach of contract. I'm going to share 3 cases which can serve as examples in your own work of how courts construe liquidated damages to be reasonable or unreasonable. The first example is from the travel industry. And in the 1980s, United Airlines licensed its computerized reservation system to travel agencies to book airline reservations and issue tickets. A travel agency named Austin Travel contracted with United for their reservation system over a 5-year term. The contract provided a liquidated damages if it terminated the contract early. The liquidated damages consisted of 80% of the remaining monthly subscription fees, 80% of variable charges, and 50% of average monthly booking fee revenues. So definitely not a clear-cut number. Halfway through the contract, Austin Travel notified United that it was no longer going to use their computer system, and United sued for breach of contract and to recover liquidated damages. Austin argued that the LDs clause was an unenforceable penalty. United justified the amount of the liquidated damages, which is another important factor that courts consider in determining if the provision or amount is reasonable. The outcome was that the district court and later the appeals court ruled that the liquidated damages clause was reasonable at the time the contract was executed and so was enforceable. On this point, it's important to note that courts place less weight on whether a better approximation of liquidated damages could have been determined, and greater weight on whether the amount of the liquidated damages was reasonable. Now, in practice, some owners may use LDs as a negotiation tactic with a contractor. And what I mean by this is an owner may tally liquidated damages for every day that a contractor is late achieving substantial or final completion, but waive the amount if the contractor agrees to negotiate other claims or change orders on the project. But owners are free not to do that and instead enforce their liquidated damages provision. The second case I'll share is an example of an owner enforcing the liquidated damages provision in its contract. It's a construction case decided by the Supreme Court of Kansas in 2009 between Carruthers Construction Company and the city of South Hutchinson over liquidated damages for a $5.5 million wastewater treatment plant. The LDs there were $850 for each day after substantial and final completion that the project was not complete. The city's engineer substantiated this number, much like in United, based on several factors, which included equipment rental to address flow situations and fines by the state health department if the plant failed to operate within permit limits at the time construction was supposed to be finished. So the project was completed almost 6 months late, When Carruthers submitted its final pay application, the city withheld over $145,000 for the 171 days late that the contractor delivered the project. Carruthers alleged that the city breached the contract by withholding that amount and that the liquidated damages provision was unreasonable. The Supreme Court of Kansas ultimately held that a liquidated damages clause is an advanced settlement of the anticipated actual damages arising from a future breach. So there's another example where courts typically uphold liquidated damages provisions and find them to be reasonable. And in this case, the LDs represented less than 3% of the total contract amount. Now, due to the freedom to contract, parties are free to negotiate terms, including liquidated damages. The purpose of liquidated damages is to compensate and make the non-breaching party whole, not so much to punish the breaching party. When a court finds that the amount of liquidated damages is significant and unreasonable, that's when they are found to be a penalty. And the third and final case that I'll share illustrates this. It was decided by the Supreme Court of Vermont regarding a real estate transaction where the purchase agreement stated that the buyer would pay a down payment and mortgage totaling $160,000. The agreement also stated that if the buyer failed to pay the purchase price or complete the purchase, all amounts paid would be retained as liquidated damages. So there was a mortgage note and deed in place. The buyer never completed the purchase, so the seller sued to collect the $160,000 as liquidated damages. The court found that there was no evidence that amount was a reasonable estimate of the seller's likely damages, and instead it was meant to serve as a penalty to induce the buyer's performance. Therefore, it was invalid. So the three main takeaways on liquidated damages provisions are that they must be a reasonable expectation of damages in case there's a breach of contract. They should be substantiated in case they're questioned in court, and they cannot act as a penalty to induce performance of the contract or to serve as punishment to the breaching party. So Mike and Jimmy, I will open that topic up to you for your thoughts and comments.
I guess I'll go first. That was a really good, summation of the law on that on liquidated damages. It's extremely thorough. We talked, but when we were planning this program, we talked, about including this one or not, because you're going to find, like Colleen, you just pointed out, like you're going to find plenty of cases out there where liquidated damages were totally upheld. You'll find, plenty of laws out there where they are completely acceptable, and so long as they're not a penalty. The problem that I've always, at least in my experience, is that quite often they're not inserted as some well-reasoned, thought-out, anticipation of damages. They're inserted simply because it gives the one party leverage over the other in order to get them to, usually it gives the owner leverage over a contractor in order to get the project done quicker. I could happily admit that I probably inserted LD provisions 100 times or more into contracts over the years, and it was always because, I knew that if a contractor was late on a project or late on providing services of some sort, maintenance services or whatever, installation services or something, that the owner is going to come back to me and say, hey, what do we do? This guy's 2 weeks late. And I can write a really mean sounding and scary sounding letter that says, you're late, and by the way, it also is going to cost you $1,000 a day or whatever the price might have been. And, and it's a really difficult position as a contractor if you've signed a contract with LDs in them to later go back and say, yeah, but that's not a reasonable expectation of the damages that might have occurred. It's a hard position to be in. You've got to make a very difficult argument, to a court or to an arbitrator. Whereas all I have to do is say, you signed the contract. So I would always caution contractors to think about that before, signing an agreement with LDs. I mean, most of the time, if you're just kind of looking through your contract, they're going to stand out to you and challenge them. Say, why do you need LDs in this amount? And is there something else we can do to assure you that I'll be done on the project rather than including them in? Because another thing that often happens is contractors, when they see an LDs provision, that's an additional risk on the contract. They'll add more money to the project or to their bids, simply because they're taking on more risk. So yeah, it's definitely a complicated one, but I think it's definitely worth flagging, and it is always one that's going to raise, your attention when you're reading a contract like that.
Sure, good stuff. All right, let's go on to, let's keep it moving, going to number 4, which, okay. Mike, this is yours, waivers of lien and bond rights.
Excellent. Yeah, so this one, I'll do it really quickly because, I think this really broadly should be just stated waivers of any kind. Specifically, lien and bond rights are important for contractors, of course. I think it is obviously a truism that some waivers are okay. For example, mutual waivers of consequential damages, those things, as long as both parties know what they're waiving and are agreement with that, there's nothing wrong with that. And there's certainly, nothing wrong with waiving liens so long as you've actually, or releasing liens, so long as you've actually gotten paid for your work. The reality of lien rights is that they've been around for hundreds of years. They are a contractor's best way to make sure that they actually get paid on a project. Public projects, of course, in most instances, you're not going to be able to get lien rights, but there's always a payment bond in place. As a contractor, you want one or the other. You either want lien rights or you want, a payment bond that's going to be in place. It's going to cover you in case you're not actually paid for the work. And the reason I don't think it's important to really spend a lot of time on this one, if you see a lien waiver in your contract that is, that would effectively waive your lien rights or your bond rights before you get paid, that is definitely something that should raise a big red flag for you as to the contract and the nature of the risk in that contract. But there are many state statutes out there that would actually make that practice, that would actually void out that particular provision if it's in your contract. Still, you don't want to be putting yourself in a position of making that argument. You don't want to be signing a contract and then have to later make the argument that, well, this lien provision is void or this waiver provision is void. But you are generally covered by state law. And this is, again, where I have to emphasize that, we're not talking specifically about any state here. We're really talking generally speaking. But I will, in the next slide, go to a sample that I pulled up from Georgia. I don't know Georgia law very well, but I did come across this, and this seemed to me like what I would expect to find if I were researching lien rights and lien waivers in almost any state. This is what I would expect to find. So definitely don't take this as me having evidence or having real knowledge of Georgia law, but this is something I found that I thought was kind of interesting. It says, in here, if you look through the language, it says that lien rights cannot be waived in advance of furnishing labor. Also, the waiver is not valid unless it's on a specified form and the claimant has actually received payment. So obviously the Georgia, state legislature, or maybe even their constitution, but probably their state legislature has really come to, a position where they really want to protect contractors. But again, you still no reason to put that into your contract if you can just strike it out during the negotiating process. Also, if you're an owner, you should be very aware that if you are looking for lien waivers or lien releases at the end of a project, which is something that you're going to want to get from all the folks who perform work on the project, you want to make sure you're getting those on the right forms. Because right here the waivers are not going to be valid unless they are on the proper form. So and in the proper form. So definitely make sure you're working with an attorney to make sure you've got all of your lien waivers and releases. So that's all. Have you, by the way, Colleen and Jimmy, I assume that this is, I don't see this very often. When I was in practice, it's pretty rare. But when I do, it stands out like, it stands out almost like it's written in red. Have you ever seen like a waiver of this kind in a contract to try to get by?
I'll go first. I haven't actually. I was trying to think back, and I can't remember a waiver this broad. I mean, the first couple that you mentioned, just kind of a general waiver of claims to get paid, like all. I mean, that's a little bit different, but no, I can't remember one.
Yeah, I would agree. I haven't come across it myself. I would just underscore the importance that with pay applications, it is important to ensure that subs and suppliers have been paid, and ideally that they are providing waivers of liens so that they don't come back at the end of the project or after it's complete requesting payment or posting a lien.
Absolutely. Yeah, lien's definitely something that, you should be very careful of, both from the owner and the contractor side.
Sure. No, thinking back to the litigation days, I think some of the more stressful days that I had were having to bond off a mechanic's lien, day of or something like that. Those are always not very fun and need to happen quick.
Yeah.
Let's go to, Mike mentioned at the beginning, we actually technically we have 6, so we broke it up into a 5A and 5B because they're kind of related. I'm going to talk about pay if paid clauses here just for the next couple of minutes. So pay if paid clauses, generally what they say, it's relatively straightforward. If I don't get paid, you don't get paid. And usually what you're talking about is somebody directly downstream of you. So if you're the contractor, you can say if the owner doesn't pay me, then the subcontractor does not get paid. Essentially what a pay if paid clause does is it shifts the risk of an owner's non-payment downstream. So you are not, the contractor is not accepting the risk of non-payment. Instead, they flow it down to the sub, or the architect's not accepting that risk. They flow it down to their consultant, or whatever the case may be. A pay if paid clause, in legal terms, it's usually referred to as a condition precedent, and you might actually find those two words in some pay if paid clauses. And it's important to remember that pay if paid clauses, usually they're not going to be like, the words pay if paid are not going to be stamped in bold letters atop the clause in the title, pay if paid, because sometimes they're not necessarily enforceable, or whoever drafted the contract might want to be able to argue that it's either a pay if paid or a pay when paid, depending upon the circumstances. So you have to read it and understand how it works. A pay if paid clause, generally, this 4th bullet point here, I was doing some research for this presentation. I came across this description of it as a reverse force majeure clause, sort of. And I thought that was interesting, particularly because the words force majeure are front of everyone's mind in light of the last almost exactly a year with COVID. But a force majeure generally says, if a superior force, if something happens that's out of our control, here's how we're going to deal with that. And that usually flows up. If a consultant to a subcontractor can't, or a material supplier can't bring in the materials, that flows up and flows up and flows up, and ultimately, it goes all the way up. But pay if paid is sort of acting in the reverse. It's saying if the owner doesn't make payment, here's how we're going to handle that. And that's out of the control, usually, of the downstream parties to the contract. You can contrast a pay if paid clause, which might be unfair depending upon the circumstances, with pay when paid. Pay when paid clause generally say, when I get paid, then you get paid. And you might be saying that's kind of the same thing. There's a very slight difference, and the difference is pay when paid affects the timing of payment. It is saying that you will get paid when we get paid, not you are only getting paid if we get paid. And what it's usually viewed more favorably, this last bullet point here, by courts, because it only affects the timing. And generally what a court does in a situation of a pay when paid clause, they can, and I've seen this happen, they read into that clause a reasonableness standard to the timing of payment if no payment is ever made. So basically, a court will not convert a pay when paid clause. Let's say the owner never makes payment. the court's not going to say, well, then that basically becomes a pay if paid clause. Usually what courts do is they say, you have to make payment after a certain reasonable period of time. And that's the subtle difference. It's not necessarily viewed as a condition precedent in all circumstances. So pay when paid versus pay if paid. You just want to go over with a fine-tooth comb, make sure, again, that it's enforceable in your jurisdiction, and if it's not, tailor it to where it will be, and you want things that are only affecting the timing of payment, not the right of payment as a condition precedent. To that, I know we only have maybe 12 or 13 minutes left, so I'll move on to 5B, unless Mike or Colleen, you want to add anything to pay if paid clauses?
No, I don't have anything to add.
All right, so let's go to no damages for delay. Always a fun topic.
Well, these clauses generally appear in public construction contracts, and they prohibit a contractor from recovering costs that are due to a delay on the project not caused by the contractor. An owner may include a no damages for delay provision on a large project with multiple contractors. But when you're the contractor who cannot claim cost lost to others' delay, this is not such an advantageous provision. Typically, a contractor in this situation is delayed by the owner's consultant, engineer, architect, or the owner's other contractors. Now, delays can add costs to the contractor side through demobilization and remobilization, being unable to use a labor force on another job, additional supervision, increased costs for materials and equipment rentals, and so on. No damages for delay clauses carry the exclusive remedy of an extension of time, which means that the contractor must absorb cost for delays that others cause to his work. The clause can also exist in the next tier of contracting between a contractor and a subcontractor. But for our purposes here, we'll look at this from the owner-contractor perspective, but know that this clause may flow down to the subcontractor. Now, AIA's A201 general conditions don't contain a no damages for delay clause. In fact, A201 explicitly allows for the contractor to recover monetary damages if the contractor is delayed by the owner's other contractors. So let's look at that provision, and in particular, the highlighted sentence. The owner shall be responsible to the contractor for costs the contractor incurs because of a separate contractor's delays, improperly timed activities, damage to the work, or defective construction. Note that this is a reciprocal provision because the first sentence requires the contractor to pay the owner when the contractor has caused delays to the owner's other contractors. States vary in terms of finding no damages for delay clauses to be permissible, and a few disallow them entirely. So it's important to research your state's laws regarding delay clauses to better understand if they're allowed and to what extent. There are many cases where courts have ruled on the validity of a no damages for delay clause. One example is from an owner-contractor agreement in New York, where the clause read as follows: no claims for increased cost, charges, expenses, or damages of any kind shall be made by the contractor against the owner for any delays or hindrances from any cause whatsoever, provided that the owner, in the owner's discretion, may compensate the contractor for any said delays by extending the time for completion of the work as specified in the contract. As you can tell, this clause is meant to be broad, so that any costs the contractor incurs for any delay, regardless of who caused it, is borne by the contractor, and the owner, at its option, may provide a time extension. Now, the New York Court of Appeals in that case carved out 4 exceptions to enforcing a no damages for delay provision, which I think are shown, here on the next slide. The first is delays caused by the contractee's bad faith or its willful, malicious, or grossly negligent conduct. And by contractee, here we mean the owner. Second is uncontemplated delays. Third, delays so unreasonable that they constitute an intentional abandonment of the contract by the contractee. And 4, delays resulting from the contractee's breach of a fundamental obligation of the contract. There are many states, such as Illinois, that recognize these 4 exceptions when evaluating a no damages for delay provision. Pennsylvania and California are 2 other states that enforce these clauses. So is Massachusetts. And an example of a no damages for delay clause upheld in a subcontract in Massachusetts is the following. The subcontractor agrees that it shall have no claim for money damages or additional compensation for delay, no matter how caused, but for any delay or increase in the time required for performance of this subcontract, not due to the fault of the subcontractor, the subcontractor shall be entitled only to an extension of time for performance of its work. As you can see, the provision is worded very similarly to the owner-contractor clause in the New York contract. Almost universally, these examples represent the form and content of most no damages for delay clauses. Up until 1998, Ohio recognized no damages for delay clauses as valid, but that year, the Ohio General Assembly declared them void and unenforceable as against public policy. Washington is another state that does not recognize these clauses, also finding them to be against public policy. They perhaps are the state that has held this position for the longest, dating back to 1979. Additionally, in 2001, Virginia also declared these provisions in public construction contracts to be void and unenforceable against public policy. So in summary, no damages for delay clause exists to disallow costs from the contractor or sub when delays are not caused by them, and the sole recourse is a time delay. If you are a contractor or sub who is unable to negotiate this out of the contract, just be sure that your overall price to complete the work accounts for this potential risk. And lastly, check your state's laws to verify whether a no damages for delay clause is valid, or if it's among the states that has rendered them void. So in the interest of time, I'm going to skip opening this for comments, and we can proceed to the next slide.
Thanks, Colleen. Do some honorable mentions. We got quite a few of them here to jam into 5 minutes, but I appreciate that on the no damages for delay. I did not realize there was such a split amongst the states on that. That's kind of interesting. So I'm going to take honorable mentions that are of a general nature, and if you can go to the next slide on that one, thank you very much. So one that it might actually be more of a personal pet peeve than something that's truly unfair is where you've got a contract that has an inconvenient forum for dispute resolution and an inconvenient choice of law provision. And a good example of that is, let's say you got a contract or a project that's in Seattle. The contractor and the design team all have a presence in Seattle, and the owner also has a presence of some sort in Seattle. But maybe the owner's, headquarters or something is in New York City, or that's where their general counsel is. And so you'll actually find in the contract a statement saying effectively that any disputes have to be resolved in a court of competent jurisdiction in the state of New York and will be resolved by New York state law. I mean, those are two things. You'll find that kind of weird stuff in contracts pretty regularly. And it's always one that I flag as, you know, I have literally never run into an issue like that where I have not been able to edit that pretty easily. The most common, you know, usually the forum for dispute resolution is going to be where the project is located, right? And the same for the choice of law. It's going to be, you know, Washington state law in that instance. So you'll see that in contracts pretty regularly. It's one that if you challenge it, it's usually going to be very easily negotiated back to where the project is. But that's one that I've definitely seen over the years and never had any problems getting rid of that type of practice. Length of contract, there's a real common perception in the industry amongst, you know, contractors, owners, and architects that the length of the contract is in some way dictates how unfair the contract might be. Personally, I do not think that's true at all, and I would really push back on that notion. And a couple of examples for, you know, the A201 that has been around for a really long time. It's 37 pages, single spaced, really got a lot of information in there. And we AIA and the folks that we reach out to, and we reach out to a lot of contractors and owners and get input from everyone in the industry. But you know, generally speaking, contractors and owners, when we send them surveys, they'll say that they will overwhelmingly they will sign an A201 that has not been edited. So it's relatively long, but it's a fair contract. On the other hand, I know I put together a lot of single-page documents that form the basis of a contract that are not particularly fair. So one-page document can definitely shift risk in a dramatic way. So it's all about the words, not about the actual pages. And lastly, if you're looking at a contract where all of the kind of bad things, the disclaimers, the waivers, you know, they're all one-sided, that's another thing that I would flag as being something that is, you're looking at a contract that's probably not very favorable to you. That's a pretty obvious point. Let's go on to the next one. Honorable mentions for contractors.
Sure. So I'll take this one, Mike. What I'm going to do is you can see them up on your screen and you can read them. Pretty much they're self-explanatory, but the one that I wanted to spend maybe 30 seconds explaining is number 2. And number 2, the contract has inconsistent contract time provisions. And what we mean by that is if your contract time is measured, let's say in days, which is pretty standard. I mean, you have 365 days to complete the project, but you have intermediate milestones that are measured in terms of a date. So, you know, July 4th, then it's not necessarily unfair to do that. There's nothing inherently unfair about it, but it's something to watch out for if you're going to deal with a time extension or force majeure issue. And how this comes up is, you know, let's say you sign a contract today for 1 year. It's March 11th. So you have until March 11th, 2022 to finish it if it's a 365-day contract. But your first milestone is, you know, let's say April 1st. You know, you need to be at a certain point by April 1st. Well, if something happens next week, you might get a 50-day extension for that, but the date might not move, or vice versa. So if you're looking at your time requirements, the contract time, you want to make sure that they either all line up in terms of days, or you just have that in the back of your mind such that if you're going to look into a time extension for, you know, one reason or another, you can account for both of those days and dates. And with that, I will turn it over to Colleen to wrap us up with honorable mentions for owners.
All right, thank you, Jimmy. So the first one here, the contract requires the owner to significantly prepay the contractor for work before it is performed. It's fairly common for a contractor to request that the owner prepay a portion of the contract amount to cover administrative expenses, order materials, rent equipment, just for that initial phase of work. But the amount needs to be reasonable. If you're being asked to pay 25% of the contract just to clear land for new construction, that amount is probably unreasonable in light of all the utility installations, foundation, framing, electrical, and mechanicals that are needed. So as an owner, review your contract carefully and talk with the contractor about any amounts that stand out as excessive before signing and beginning the work. Second, the contract allows the contractor to disclaim typical warranty obligations. This can be broken down into 3 types: express, implied, and statutory. An express warranty is written in the contract. It includes things like the contractor warrants that materials and equipment are new and of good quality. Work will conform to the contract documents and be free of defects. Contractors also generally provide a 1-year warranty after completing the project to correct any work the owner finds is not in accordance with the contract. The best example of an implied warranty is that of habitability, which runs from home builders to the home buyer. Implied warranties exist at common law. They're implied, so they don't need to be stated in a contract, and they can't be waived. Third, statutory warranties are passed by legislations, and the statute will automatically apply to the contract. Lastly here, the contract cuts the architect out of the process, particularly reviewing payment applications. On some projects, especially residential where there's tract building, there simply won't be an architect present during construction. So the architect won't review any pay applications. Now, for most other projects and those without a construction manager, it's standard for the architect to provide some level of oversight for the project to assure the owner that the contractor is building the job according to the architect's plans, and to confirm when the contractor completes various phases of construction so they can certify payment by the owner.
You can learn more by visiting aicontracts.org/learn. If you have specific questions, they usually fall into 2 categories. If it's a question about the content of one of our documents, you can contact us at our content docinfo, and that's the contact info on the middle of your screen. And if you have questions about our online service and the software, that's the contact info on the bottom of your screen. And with that, we want to thank you all for hanging out with us today. We went a little bit over, but we hope you found this information helpful, and thanks a lot for stopping by. Appreciate it.